The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have two cases that will be submitted. Those cases are Dennis Willard versus State of Iowa, and the second case is in the matter of the estate of Joseph Gartner III. That last case, the second case, is now submitted to the court without an oral argument, and we'll proceed to hear the arguments in the Willard case. Mr. Thompson.
Thank you, Chief Justice. May it please the court, counsel. Preventable medical errors are a significant cause of morbidity and mortality in our nation's hospitals. This cause of morbidity and mortality is best reduced by a systemic approach to patient safety, a dedicated process to track and study adverse events that occur throughout an institution. The patient safety net is the process UIHC uses for this purpose. The patient safety net is how UIHC gathers essential information to be used for the purpose of reducing morbidity and mortality. The district court's determination that this information is not subject to Iowa's morbidity and mortality statute and the protections therein ignores the plain meaning of the statute, thwarts the intent of the legislature, and threatens a process that enhances patient safety and reduces morbidity and mortality. The protections of Chapter 135 apply to the PSN, the Patient Safety Net information, because it was provided for the purpose set forth in Section 135.40. And because it was, the PSN information is subject to the confidentiality provisions of 135.41. The PSN information may not be used in any legal proceeding under Section 135.42, and the PSN information is not subject to discovery, both because 135.42 says it may not be used in any proceeding, and frankly,
it says offered or received in evidence. That's a little, use is a little broader than offered and received in evidence.
Well, it says use too, Your Honor. I mean, it says all three, and that's the point is that plaintiff's argument and the district court's ruling truly reads use right out of it, because the argument is, well, this really just means it can't be used in evidence at trial, when the statute says used or offered or received in evidence, and there are clearly three different aspects of that. And it couldn't be broader, frankly. The other thing that's important is that in this court's own interpretations of Rule 15031, frankly, where you have a bar on the use in trial, if you read it narrowly in admissibility, this court, in the same type of situation, 622.10, have interpreted that as a bar to discovery. So we have both the bar on use in the statutory provision, and then this court's precedent under 622.10, cases that were decided before 622.10 even had the word privilege.
Mr. Thompson, I'm not so troubled by this issue of if there's a privilege, is it just an evidentiary privilege, or is it also a discovery privilege? But I'm more troubled by this hearing record we're dealing with, the record that was made below, including the specifically the testimony of Ms. Thoman. And the statute says to be used in the course of any study for the purpose of reducing morbidity or mortality. And what she testified is, well, it could be used for various purposes. One of the purposes it may have been used for, but I don't know, is for the purpose of morbidity or mortality. Is that good enough?
Well, I think so, although there are other aspects of her testimony that I think are real important. I think it's important to remember that the statute doesn't, as crafted by the legislature, says may provide to be used. in the course of any study for the purpose, et cetera, et cetera. Nowhere does it say must be used. It doesn't have a provided however provision that says if it's not used, it's not protected. And so it doesn't say it must be used. In fact, it deals with the gathering of evidence for a purpose, to be used for this purpose. Now, in the hearing transcript, if you carefully read the questioning, I mean, what she said was, I cannot say whether or not it was used for a specific study or a specific purpose. She also testified that the PSN doesn't track the end use of these things. It aggregates data, it is reviewed along the way, so there's no way, kind of an after the fact, to analyze how a particular data point is utilized, but most importantly, I mean, she testified about how the system works.
She also said sometimes these things are used for conferences or for research. You would agree that's not enough under the statute, is it?
Well, I mean, under the statute, it talks about research. And so, I mean, to the extent that you're teaching, you're publishing papers, you're educating, you're teaching doctors in a teaching hospital like the University of Iowa about practices that may lead to unintended consequences or ways to reduce morbidity and mortality, yeah, I mean, I think it does. But to your point, I mean, I think the focus of the statute is for use in any type of study, because it's very broad, that the purpose is to reduce morbidity and mortality. And that I think when you look at her testimony as a whole, what you see is that the patient safety net is a study. I mean, it is the process by which the University of Iowa hospitals collects the data necessary to investigate patient safety. And if you look through the record, I mean, and I can give you the sites, but she says it's part that the PSN, the patient safety net, is part of the M&M process or system at the University of Iowa hospitals. She said the PSN is how we collect data on patient safety, that this is the mechanism to study adverse outcomes, and that this is how we study ways to improve outcomes. This is how we study ways to reduce morbidity and mortality. That PSNs are always, in every instance, reviewed by the safety department. So whether they go this way or left or right, they are always reviewed by the safety department. So they become part of the data that's collected to look for trends. But also, if there's a specific event that needs to be investigated, it goes, as you read in the testimony, to different steps through a process, through different committees. But she testified that the quality department is the equivalent of an in-hospital committee that oversees patient safety. And the purpose of all this is to reduce morbidity and mortality by reducing avoidable, preventable adverse outcomes.
If these materials were discoverable, would that affect how nurses and other people involved in an adverse outcome would whether they'd turn them in or how they would fill them out?
Absolutely. I mean, you heard her testimony. She said that it's very important that there's also an anonymity provision here. You don't have to put your name down. So it's confidential in the sense. And if you step away to what's going on here, this is designed to encourage a floor nurse to file a report that may say a doctor or a surgeon or somebody that is way above he or she in the pecking order is doing something that could affect patient safety. Or as simple, I mean, I know that there's kind of a comment about how, well, this could be used for falls or this could be used for a missing ring, but we're in a surgical hospital. I mean, so obviously falls are very important, but this is intended to encourage a report of anything that somebody believes could affect patient safety. And so a missing ring, when you do an inventory in the room of somebody who's come out of surgery or has been, in an emergency room, I mean, we can scoff at it, but that could be a huge deal. But the point is, it encourages. You heard her testimony that sometimes it's not reliable, sometimes it's hearsay. But you gather data, you triage it, everyone gets looked at, and then they follow a decision path as described by Ms. Thoman. This is
Why
exact.
wouldn't you use the similar language that they have in the peer review statute if that talks specifically about discovery and things of that nature, and we have case law that talks about that? Why wouldn't the statute contain a similar type of revision? Or are you saying that the mere fact that they have used is the same as discoverable?
Well, three things, really. First of all, this statute was drafted in 1963, and so, and it's not ever been challenged before. People have operated with this belief that this is really a privilege and protects this information since then, frankly. But yes, I think use is a broad term, and it can be read to say you can't use it for any purpose in a legal proceeding of any kind.
It was also modified in 2006, and so
Correct.
some of the provisions here, so I think in response to federal legislation, I assume. And I guess my question is, it just seems like we're trying to fit some information within this, what I consider to be a very poorly written statute, and then comparing it to other states that have actually more formalized that, what I call patient safety work product exclusion, which is, I think, what you're trying to say this is, isn't it?
To some degree, but again, keep in mind, I agree, I'd much rather be up here with a really more carefully parsed statute, but it is what it is. It's broad. Let's face it, it's broad. And coupled with this court's rulings in Chung and Ashenfelter and other cases, that under the context where you have, even if you just call it a statutory bar to admissibility, frankly, it's not discoverable under this court's interpretation, at least of the peer review literature or the peer review statute. And in Burton, the one thing this court has already said about this statute is that the public policy issues that come along with the peer review framework apply with equal force to this statute. So I mean, I think the answer is we sometimes, I don't think the legislature has been confronted with a problem that use, offer, or receive into evidence is very broad in terms of the prohibition on litigation use, which is one of the things built into this. And this court's jurisprudence on Rule 1503, bolster that means it's not discoverable even if there's any doubt. I think the statute handles that. And then when you back up to the Burton court's interpretation of 13541, interpreted it as a broad confidentiality provision, so strong that it withstood a challenge under Chapter 22. So I think that doesn't cry out for a legislature to fix, at least at this point. So I think it's important to note that as I said, 622.10 didn't even use the word privilege until 2011. And even the peer review statute until 1986, I believe, was just one paragraph, right? So, I mean, a lot of that detail is something that has evolved over time. The M&M perspective, the patient safety world is slightly different than peer review. It's been less litigious, frankly, because you don't have doctors being, their privileges being taken away. But it's also true that now state regulations and federal regulations require a safety program like this for the purpose of reducing M&M. And the amicus briefs, I think, do a good job of laying out the scope of the concern here and the public policy interests.
Is a shoulder injury, does that fall within morbidity?
Yes. I mean, I think we cited a definition from Medline Plus, but I mean, morbidity is symptoms, is sickness. And in Medline, there's even an example that says lumbar puncture, if improperly performed, may be followed by significant morbidity. So this idea that, I mean, when you have symptoms, when you have outcomes adverse to patients' well-being, that increases morbidity.
Putting these 20 pages off limits for this lawsuit, is that going to prevent the plaintiffs from proving their case?
No, absolutely not. In fact, this record, again, this is a strange thing, so there's only a handful of people that have seen what's really in those records. You have, I have, but you've also seen the medical records that are attached to the plaintiff's motion, where there's detailed discussions in the regular medical records of the shoulder, of the manipulation to put it back, that it was dislocated, the time frame in which it was discovered. All those things are in the medical records. The statute expressly balances this issue by making clear that nothing in this statute infects the admissibility of the otherwise admissible regular medical records. The real difficult thing here is that you're faced in the context of a statutory interpretation problem with these interests that are at odds.
Mr. Thompson, would it be discoverable the person who made the complaint rather than the report itself?
No.
Why not?
Well, because it's that information in the PSN is information provided. It's only in a report created as part of the PNN for purposes of M&M. And so,
What if my question said, please list all persons who have any knowledge of the incident?
well, that person's name, if we know it, should be in that list of people with knowledge of relevant facts.
And then-
Absolutely.
And then when I ask that person, well, how do you have knowledge of it?
Well, and then you're going to be talking to either a witness or somebody who
I
was
mean,
told.
what does
or
that
saw.
person say? I filed a report?
No, that's not the question. I mean, if you ask the question, did you file a report and why did you file a report? Now you're going down this path. But if you say Nurse Smith, how do you have any knowledge of that? She'll say, you know, I was a technician in the CT department,
can't-
or I moved Mr. Willard from point A to point B and noticed that he was in pain.
But why can't they ask, did you file a report? We're not asking what kind of report. Could have been a medical report, it could have been any
Well,
kind
I
of
mean,
report.
probably what would happen is you would ask, and she might say, yes, I filed a report. It's factual. It's not something, but I mean, at
The
that
next question-
point, I don't think that the report, or, I'm sorry, go
Then
ahead.
the next question would be, what did you report? I think this was an error. I mean, you could ask that question of somebody.
I think so.
So aren't we just playing semantics and games here?
No, not at all, because this report is a report. It's reviewed by nurses, by management. Although this one doesn't, there could be conclusions, and again, the statute expressly says information, reports, and then when you get down to the provision that deals with evidentiary issues, both the information and any findings and conclusions. I mean, so it's a self-critical analysis privilege is what this is. And yes, you weigh public versus private interest. The legislature did that. You can tell by the fact that they look at this issue of admissibility of other things. I think that, you know, your statutory framework for interpretation of statutes instructs you that when the legislature passes a law, that you must presume that the public interest that it addresses is intended to outweigh the private interest at stake. I mean,
What if I ask the question in interrogatories, can you list all people who may have been critical of what happened? And you list those names, right? You list that name, won't you?
I think it's a tougher question. I think that that's probably a finding or conclusion that's shielded in a different way.
Yeah, but a lot of people are critical. I mean, sometimes
Yeah.
doctors are critical of other doctors and they don't write reports.
But I mean, if that's the only reason, I think the fact that a good lawyer could scriven around this isn't reason for you not to enforce the law as written, to be honest. I mean, I do think all your questions show that this doesn't slam the door on justice, that medical records are admissible, that witnesses can be but they just can't, you can't use this information or this report in the way, frankly, that plaintiff's counsel suggests in his brief, that, well, if I could always depose a witness with it or cross-examine a witness with it, that's what the statute says. You can't do that. That's the whole point of use, because that's why they added that language.
But
you
that
know, the
seems to
police
go to-
report.
That seems to go to the trial. It doesn't seem to me to go to the discoverability of it.
Well, I think that.
You're gonna cross-examine somebody, if you're going to try to put it into evidence, so to me, it really does concentrate on the 135.42, which is the unlawful use of this information. And I don't know that there is a huge dispute about whether or not the privilege exists. It certainly may exist, but the core issue is whether it's discoverable or not.
Right.
And whether this language really prohibits the discovery of this information, and then you compare it to the cases like we talked about earlier when we deal with peer review, which it clearly shows that it's not discoverable.
Right.
And the legislature could have said that here, but it didn't. And
Right.
so that's where I'm coming from, or I want to have you respond to that.
All right. Well, and keep in mind, in 62210, legislature didn't say that. You said that. And I think that I believe that, as I said before, that the word use is a broad term. It says use in any legal proceeding of any kind whatsoever, essentially. And that to argue that discovery, for the purpose of using it to discover admissible evidence, isn't use in a legal proceeding, since it's a legal document, a discovery request by which you obtain it. I mean, I think discovery is use in a legal proceeding, just like using it to try and take a deposition or anything in the context of that lawsuit. And so I think the statute itself is sufficient to reach the conclusion that it's not privileged. But again, I go back to that in a similarly situated, from a public policy standpoint, statutory framework, 62210, this court has repeatedly said the discovery is carved out and discovery is not permitted because it defeats the purpose of the statute.
Why isn't the used language in section 42 qualified by the phrase "in evidence"?
Well, we can go down the path of the last preceding antecedent rule. I think the Cairns case, if I say it right, really kind of sets it out really well. First, it says, look, what you really do is you look to see where it makes sense. When you look at this qualifying phrase, you look at where it makes sense.
Well, how about the word "offered"? How does that make sense without putting it in the context of evidence?
I think you can parse it either way on that, but I think that if you apply the general rule, I think that it modifies received. But I think, again, if you're looking at charting the sentence structure, you could say offered or received into evidence. But it's received into evidence. It's not in evidence until it's received, offered at any proceeding, whether it's offered in evidence or not. I mean, I think you can construct something that works just fine. In no account do you have to embrace used in there in a way that limits it to in evidence, because that makes no sense, Your Honor.
Thank you.
Thank you.
Mr. Reilly.
Thank you. This court has made clear many times the law favors full access to relevant information. In discovery, the rules are to be liberally construed to effectuate disclosure of relevant information. When a party claims a privilege, they have the burden to show that not only the privilege exists, they have the burden to show that the privilege applies to the facts of the case. And when a privilege is statutory, the terms of the statute dictate the privilege.
Wasn't the testimony that they collect this stuff to look for patterns and things, and maybe one document in and of itself may not create the pattern, but and they may not use it immediately as they collect it, but they collect it, classify it, and then look for patterns to prevent mortality and morbidity. And doesn't that get you under the statute?
I don't think, no, and I don't think really that's what the testimony was. I asked, what, they say it may be used for this. There's a lot of, it may be used for that, it could be used for this, it could be used for that, okay? So then
Say hypothetically it went to the safety oversight team. That's a committee, right?
and in
A
hospital.
team is a
okay.
committee, right?
Okay, so then it went to a committee.
All right,
Okay,
and
we
then,
give that.
and would you agree it's a committee with the purpose of reducing morbidity and mortality?
But it's not okay, but the statute doesn't talk about reducing morbidity and mortality. It has to be used in the course of any study for the purposes of morbidity and mortality. So used in the purpose of any study. And it doesn't say the study generically, like they're generally looking at it. It says any study, okay? So it's referring to a study. The research, so to me, I mean, again, they could have used the word a study, or the study. The study is generic, broad. We're looking at patterns, right? Any study is referring to a study, a specific study. I mean, I think that's the fair reading of the
But they're collecting the
statute.
data when something untoward happens in the hospital.
Sure.
And it may be an isolated incident, which has one way to take care of it, and it may be a pattern that maybe the bed rails on this type of bed fail more often than not. Or maybe they don't clean the floor, or they're using the wrong kind of wax on the floor and causes someone to fall. I mean, it seems to me that you can do a study and it may not go anywhere. I mean, there's all kinds of studies that say, well, we looked at the study and we have no conclusions from it.
Yeah.
So if they collected for the purposes of seeing whether there's patterns that they can change the way they do business, isn't it in fact being collected for a study?
If they're looking, I guess I don't, no, I view that more, that would be the study, not a study. Yeah, you can have a study that doesn't go anywhere. Yeah, it's like, okay, there's no measurable results, we don't do anything with it. I guess I don't see it that way. Specifically, we had the ring example. To me, that's significant. They said if not the patient, but if a family member, if somebody is there, a visitor loses their ring, it's the same form, okay? That she does not know how this PSN was used.
We say the ring is not protected, but maybe this is.
But the process, they want to say this process is protected. I'm saying you got to look at a case-by-case
I
basis.
agree, we don't need to accept the entirety of a litigant's argument, though,
Sure.
right?
So I think we got to look at it, the facts of this case. We don't know. We can't just say every PSN is privileged, which I think is what the state wants to say. We got to look at each particular case because it has to be used in a study. So what's the state witness own say? Well, they admit that they don't know how the PSN was used in this case. They cannot say whether the PSN at issue was used in the course of any study for the purposes of reducing morbidity and mortality. That's a significant admission. They can't, the state's own witness, they have the burden to prove. I don't have to prove anything. They have to prove that the privilege exists and that it applies to the facts of this case. They cannot say that that form was used in the course of any study for morbidity and mortality, okay?
If we look at the document and it gives us more information, can we rely on that?
If we look at so we look at the PSN, I don't know what it says. Everybody here has seen it except me. So I'm hard pressed to,
And nobody, and you made a good record at the hearing, and the lawyer on the other side is not the lawyer representing the state today, so we have to deal with that as well. So I recognize that.
okay. But yeah, I mean, I thought a great record was made because I thought it was very clear that the state could not prove how the particular PSN in this case was used. Because it really boils down to, data has to be furnished in accordance with the division for it to be, if there is any privilege under 142, it deals with, the data has to be furnished in accordance with the division. Again, to be in accordance with the division, it has to be furnished to a subcommittee. It has to be in the furtherance of a study, any study for morbidity and mortality. So then, I mean, if we get to the point that we say, well, maybe it is subject to the division, then we go to section 142, and what does that say? Well, yeah, we talked about you cannot use and offer and receive, and talked about the doctrine of last preceding antecedent. But what it says is qualifying words and phrases refer only to the immediately preceding antecedent unless contrary legislative intent appears. I think there's a little discussion about this, but certainly you cannot receive an evidence if you buy this. You cannot receive, again, data furnished in accordance with the section. You cannot use, or I'm sorry, information that is received in evidence you can't use. Well, the word offer without evidence doesn't make any sense. That's one thing. I think if it's received in evidence and offered in evidence, you have to read it to be used in evidence.
Here's the problem I have with that is offered in evidence, that's a common expression. Received in evidence, that's an expression.
Sure.
Used in evidence, that sounds like something my son used to say when he was in middle school mock trial. It's not something a lawyer would say. And so reading that and recognizing we need to give some effect to the word used, why can't we read that to just mean used at all in the proceeding?
Well, I guess I'd say this in two ways. To me, it makes sense because used in evidence, impeachment. You don't offer or receive impeachment. When you use impeachment, you're using it in evidence, but you cannot, generally, an impeachment evidence cannot be offered or received, or isn't offered or received. It's used, though. If used means what the state says it says, why have offered and received? If you can't use it, then you obviously can't. Use is broader than offer or receive. And again, I mean, when construing a statute, no part is rendered redundant, irrelevant, or superfluous, and it's presumed that the legislature enacted a statute, each part should be given effect. If use means everything, you cannot use it. That means, by definition, you can't offer or receive it. So why have offer and receive if use is as broad as they say? Again, the only thing that makes sense to me is if you cannot use it in evidence, for example, impeachment, you cannot offer it in evidence, and you cannot receive it in evidence. And another thing to keep in mind, I think an important thing we're dealing with, is
So used in impeachment is used in evidence? I mean, even that, I've never heard that expression before.
Okay.
I mean, so you're saying if I showed the document to the witness but didn't attempt to introduce it, that would be using it in evidence?
Sure. I'm not saying I've used that term, but I think that's a correct description of what happens.
If you have used modifying legal proceedings, used in legal proceedings, offered in legal proceedings, received in evidence in legal proceedings, I mean, use could be impeachment, refreshing recollection. There's many ways that documents are used in a litigation there or they're not offered or received.
Oh, absolutely. But if you cannot use in a legal proceeding, that means that's everything, right? I mean, because if you can't use it in a proceeding, you certainly can't offer it or receive it. So you wouldn't need the words offer or receive. And so I think I don't think it's a fair reading of use.
And the peer review statute would be redundant, because isn't that the way that one works?
Well, but again, the peer review statute goes so much further on what you can and can't use. I mean, I think it's a bad analogy to the present case. And particularly, I mean, it hasn't been talked about yet, but 135, 142 also says specifically, and I think this is really important, it says that the section shall not be construed to affect the admissibility as evidence of primary medical or hospital records pertaining to the patient, okay? And what does this mean? I mean, in all honesty, okay, the statute makes sense to me, and here's how I view the statute. It allows medical societies, hospital committees, other people to get data they probably couldn't otherwise get, about all kinds of people getting infections and dying, and they can get data and they can do research. This type of data they might not be able to get without the statute because it's privileged under HIPAA and other statutes. They can get the data from all these other people. They can do studies about the data. And you can't go after these committees or these societies and get the information, okay? But what this is saying, the section I just read says, the actual patient, they can get their hospital record. Certainly if the subcommittee or the medical society has all these other pieces of data, there may be limitations to who people go in and getting that information.
Back to, if the purpose of the statute is sort of to protect people who might, like people who are relatively low in the hierarchy within the hospital, protect those people who might be afraid of retaliation or things like that if they reported something that somebody who makes a lot more money did that they thought was wrong, wouldn't the legislature have wanted to protect the document from discovery and not just from being used as evidence, if we want to use that phrase, in the trial?
I guess if the legislature wanted to do that, we'd be looking at a very different statute. That's not the statute I read. If the legislature is trying to do that, I think we'd be looking at a very different statute. But the legislature specifically says, again, that it doesn't affect admissibility, not only discoverability, I get admissibility of evidence of primary hospital records. Hospital record is not a defined term. It says medical records and hospital records. So hospital records are by definition different than medical records. I got my client's medical records. But isn't a PSN a hospital record relating to the patient? Again, since I'm representing the patient, I should be able to get medical or hospital records relating to the patient. I might not, if I was suing the hospital for an infection, right? They had a secondary infection, and the hospital had a study about secondary infections. I might not be able to have access to information about other people. But if they have a hospital record relating to my client that pertains to my client, 142 actually specifically says I get that. It says it's admissible. We talk about whether it's admissible, discoverable. It's admissible. So by definition, if it's admissible, it's discoverable.
Doesn't that just refer to the other 5,000 pages of hospital records that you do have?
What's that?
Isn't that just a way to avoid the hospital, for example, from putting information into a PSN and saying, aha, it's now protected? So the normal medical and hospital records, which you have, including the x-rays that show the shoulder dislocation, those are admissible. This statute doesn't make those inadmissible, but it protects the PSN. If you read it as a whole, the specific terms control over the general.
But specifically, I get medical records and hospital records.
But PSN records are a specific subdivision, and they're treated, they get the confidentiality under the statute, and then that catch-all at the end says, hey, hospital, you can't hide the rest of your records in this type of case. They're admissible. I mean, that seems to make sense to me.
Primary medical or hospital record, that means like when I go to University of Iowa, for example, and they called me up on the computer and there's a stack this high, those are the primary records.
The medical records, but not it says medical or hospital. Again, a medical record, we all know what a medical record means, but it uses the word medical or hospitals. I mean, I would suggest that a hospital record is different than a medical record.
Could a PSN record also?
I'm sorry?
Could a PSN record also be a hospital record
I think a PSN record is a hospital record.
in every instance?
Well, it's a hospital record the statute, it's a hospital record pertaining to the patient, okay? So the patient should be able to get hospital records pertaining to the patient. Maybe not to third parties, but the patient should be able to get a hospital record pertaining to the patient. I think the section, I think, is pretty clear. So, I think in a nutshell, I mean, I really do not think that they met their burden of proving that the privilege applies. They didn't approve. I mean, we can disagree, and maybe I'm shut down here, but I don't think that they have proven, and they had the burden of proof, that it was furnished, the information was furnished to a department or in-hospital staff committee. Again, I asked who did it go to, and they said apparently you can see it. She said, my recollection is what she testified, that you can see who viewed it. They didn't know who viewed it. They didn't know whether it was viewed. They didn't know whether it was reviewed as peer committee. They didn't know what was done with it. So again, they can't. It wasn't furnished. They haven't proved they furnished the right people. They haven't proved that it was used in the course of any study. I asked that question specifically, and she said no. So the evidence is they don't know whether it was used or furnished. I still think morbidity and mortality use the definition. I don't think a shoulder injury is morbidity. The section we heard, he mentioned about puncturing could lead to morbidity. Yeah, it can lead to infection. Infection is an illness. It didn't say if a puncture was an injury, if an injury was morbidity, a puncture would be morbidity. Instead, what the portion that was read was a puncture could lead to morbidity. In other words, a puncture can lead to infection and illness. So they didn't prove that morbidity or mortality applies. And then I think you go to 142.
You may sum up your argument then.
Okay. So, finally, I think that well, I see that my time's up. I guess I would note for the record that about 8 minutes went before his clock started. But that is what it is. But thank you again.
I'm sorry, what did you?
About 8 minutes went. I was watching my clock. His clock didn't start for about 8 minutes into his argument.
Oh, do you
No, I'm
need
fine.
some more time?
I'm fine. So thank you.
All right, rebuttal, Mr. Thompson?
Let me go back to just a couple of issues. I mean, on the discussion about the regular medical records, I think a couple of, Justice Waterman asked the question, but I think the statute very kind of carefully parses the distinction between the M&M and the standard records. And if you look at it, not only says the primary medical or hospital records pertaining to the patient, et cetera, this, the list of stuff he or she can get, but it also says not contemplated by this division. So I think it makes a very clear distinction between all primary medical records and what's created for this purpose, which is why PSN is a separate system for this purpose. On the issue of statutory privileges and kind of separate components, the Justice Mansfield in the Cawthorn case, which was a peer review case that dealt with kind of a complicated waiver question, you went back and you said in the context of a statutory privilege, you look at what the statute says, and there are three elements to this privilege. It says it's privileged, it says it's not discoverable, and it says it's not admissible. And the fact that non-admissibility was a separate standalone provision is what really drove the discussion about whether there was waiver or not.
How do you answer his argument about it's as a hospital record pertaining to the patient?
I think I just did, Your Honor. I think that what it says is it's not contemplated by this division. In other words, it's not created under 135.4 for this purpose. So
I could see peer review are not hospital records pertaining to a patient because they're gathered for credentialing and qualifications of doctors to continue practicing in the hospital. But this is an actual, report of what happened. I mean, if this appeared in the nurse's notes, that the gentleman came out of the CAT scan and his shoulder was dislocated, we wouldn't say anything, would we?
And he did, actually. But my point is this is a carve-out. 135.4.2 carves out, a notwithstanding provision and makes clear that it's carving out stuff that's not created under this, that's primary records not contemplated by this division. So I think it's clearly saying there's a distinction. But back to the Cawthorn case, I mean, Justice Wiggins, you also, in your concurrence, pointed out that in the context of a statutory privilege, that all the other kind of analysis really isn't as important as looking at what the statute says. And in this 135.42, it says use, offer, receive, and there's got to be a meaning to those things. And I think that that's the nature of this kind of statutory privilege. I think, but to go back to the beginning of counsel's argument, Justice Wiggins, I mean, you asked, I think, the most important question, which is, well, if they don't use it right off, and then they keep the data, which they collect this data, and they look for trends, but then they later see a trend, and so they do a study about it, then does it become, under his argument, does it become confidential? And so under the argument that's being made, under the argument that the district court accepted, you have this situation where, frankly, by nature of the intake provision, nothing would be confidential until the point in time when it's actually used in a study, and that at some point in time, stuff may or may not become confidential in the future, and it doesn't make any sense. That's why the statute has to be read if this is created apart from the primary record for the purpose of doing any study to reduce morbidity and
And
mortality.
here's the question that occurs to me. If it gets to this in-house committee, this safety oversight group, at that point, isn't anything they're doing a study to reduce morbidity and mortality in a sense?
I mean, I believe that the right answer here is that this whole thing, studies start with data, this whole thing is a study to reduce morbidity and mortality, that the act of collecting the data is part of the study. The triage that the quality department does is part of the study. They look at it, they decide whether it goes this way or whether it goes that way. They keep it, it goes in the database so that next time they get a similar thing that they may want to kick over here, it shows a flag, it shows a trend, and that each of these steps is a different kind of analysis. The safety oversight, the SOT team, does a certain kind of analysis. Depending on their decision, it goes to root cause analysis. But it all begins with the collection of data, like any study, and that without the data, there is nothing to study, and that by deciding whether the data is valuable or not valuable, is in or is out, turns left or turns right, that is a study. And the purpose of the whole system is to basically improve patient care, to reduce preventable mistakes and errors, and to reduce morbidity and mortality. And it fits so cleanly when you view it that way into the statute and the clear language of the statute. So for those reasons, I think I'm wrapping up. We would encourage you to interpret the statute really consistent with the Burton case's interpretation that the public policy issues in peer review are just as important in M&M, and reverse the district court. Thank you.
Thank you as well, Mr. Thompson. The case Willard versus State of Iowa is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.